Hi, folks. Welcome to Crisco's Corner. Folks, welcome back. From the post-millennial, Biden's Supreme Court nominee once argued judicial system is unfair to SCX, PREDATORS. I spell it because the algorithm is already working against me. I don't want to make it worse. Even in the face of understandable public outrage over repeat SCX blank, a principled prevention punishment analysis evaluates the effect of the challenged legislation in a manner that reinforces constitutional safeguards against unfair and unnecessary burdensome legislation. Now, I have somewhat of a personal stake in this. One of the proudest moments I had as a city councilman in upstate New York, I was a council member from 2000 to 2007. I think it was in 2004. We submitted SEX offenders. We submitted legislation concerning how they register, local law enforcement visitation and other county bureaus for visitation, tracking their movements, especially the higher level ones. And that legislation actually made international news from a little town like Binghamton in upstate New York. We made news. We had inquiries from England, Australia, Canada, and other countries as well, trying to get a copy of our legislation to maybe in their cities and states and areas what we were doing. And I was pretty proud of that. For a little city council to make international news, it was really something. But I digress. Let's move on. President Joe Biden's Supreme Court nominee, Judge Brown Jackson, once authored an unsigned note in the Harvard Law Review arguing that America's judicial system is unfair to XCX blank, according to findings discovered by the American Accountability Foundation investigation. Now, why would she put an unsigned note if she really believes in what she was saying? Oh, she doesn't want the personal ramifications. Oh, I see how that works. Jackson argued the unconstitutionality of certain preventive measures adopted as common practice by state governments and applied to confirm SCX blank. Now, I do have to say, we got a lot of pushback from the legislation I was part of in the early 2000s from the state of New York. I won't go into details. I think some of the people that were with the state meant well. Some didn't. It's just the way it goes. We're in a deep blue state, and that was a lot less blue than it is now. Per the Harvard Law Review article, Prevention versus Punishment toward a principled distinction on the restraint of released SCX blank. She argued that America's judicial approaches might be unfair to XCX blank. Now, my particular opinion, and this is just mine, doctors, people that are a lot smarter in, I call it mental disorders or psychology or whatever you want to call it. The vast majority, especially the higher level ones, we'll just talk about them first. The higher level ones, there is no cure. There is no cure, period. Once you deal from that premise, then you come up with decent legislation. There's no critique certain judicial approaches that characterize the XCX, OFF, enders, statutes, and suggest a more principled framework for making the distinction between prevention and punishment. How do you do prevention? Follow them around all day? Make sure we have a police officer in every single public park? Every single playground outside of schools? What do you do? Take a cop and have 3 cops do rotations? 4 cops, actually, counting weekends, to do rotations to follow these people? That's just untenable. Jackson maintained even in the face of understandable public outrage over repeat offenders, a principal prevention punishment analysis evaluates the effect of the challenged legislation in a manner that reinforces constitutional safeguards against unfair and unnecessary burdensome legislative action. I know what she meant, but that's damn near close to word salad. State laws across the United States widely use preventive measures like offender registration with local law enforcement, DNA identification, requirements to notify neighbors and surrounding communities, which we have here, and others to reduce the likelihood of a second offense. That I go along with. These, Brown argued, aren't only preventative, They're punitive. In other words, they're used as a punishment that goes beyond the court's verdict for a specific crime. It's a punishment applied more generally to all XCX, OFF enders. And that Jackson argued might not be constitutional. Well, you know what the other recourse is? If they get small jail sentences, if any at all, and those other measures like registration, notification, notifying the surrounding community that this individual or individuals in the area, then we'll just give them 10, 20, 30-year sentences. Is that what you want? I certainly wouldn't want to be incarcerated for doing those offenses. It makes you a target number one. And target number two, there is no cure. This is the best solution of an impossible problem. There is no solution. This is the best one. Although many courts and commentators herald these laws as valid regulatory measures, others reject them as punitive enactments that violate the rights of individuals who have already been sanctioned for their crimes. Every single convicted felon, when filling out a job application, whether online or in person, I like doing it in person. I don't like online applications. You're always asked if you ever committed a felony. Always. Is that punitive too? I don't know. Under existing doctrine, the unconstitutionality of XCX statutes depends upon their characterization as essential, preventive, rather than punitive. Yet courts have been able to devise a consistent, coherent, and principled means of making this determination. Because there is no perfect solution. All the solutions are crappy. This is just the least crappiest. I mean, I know that's not a legal term, but that's the way normal people talk. However, her reasoning is one of legal precedent, however. That's the catch part. State governments have been using these practices for decades. She argued from a position that looks to protect offenders from what she described as a cultural atmosphere of hate. Here we go. This sounds familiar. In the present climate of fear, hatred, and revenge associated with the release of convicted XCX criminals, courts must be specifically attentive to legislative enactments. They use public and safety rhetoric to justify procedures that are in essence punishment and detention. She acknowledged the authorship in a note to the Judiciary Committee, including in a list of authored works, while the Senate considered her nomination to become judge back in 2012. Her written work is also confirmed by Intelligentsia in a feature profiling Jackson, who the outlet says shown a deep interest in trying to ensure a fair process upon unpopular clients. Americans want our judicial system to protect children and citizens from XCX predators. Judge Jackson Brown's radical position raises questions for still ability to sue on the court. Is she more interested in social justice engineering or administrative justice? Yep. Another progressive intellectual that has no idea what it's like to live in the real world. And if she has when she was younger, she has long forgotten about it and long left that world a long time ago. We're going to have to eat this one, folks. Conservative, moderates. We're going to have to eat this nominee or one very similar to her. I think it's racist as hell to say you're going to nominate a black woman and leave all others off the list. That in itself is racism. But here's the thing. Back many years ago, I believe it was under the Bush administration. I could be wrong. It could be under the Reagan administration. There was a black woman that was a nominee to the Supreme Court. The Democrats said no. Why? They wanted credit for being the first to nominate a black woman. So they killed her nomination. That's the Democrat Party that you people belong to. And that's the Democrat Party. That's the racist party. It has been and always will be. Until the next time, goodbye and good luck.